We will be discussing Chapter 7 in our PowerPoint presentation. Our outline includes abuse of power, individual rights, search and seizure, arrest, and intelligence function. At the end, we will have a pop quiz along with discussion questions.
Abuse of power has always been a conflict between the suspects apprehended at the crime scene and the police. With the new installation of body cams, we are now able to find out whether or not the police abuse their power to the subject or suspects, or whether or not the suspects are lying in order for the court to have their way. In the 1960s, the U.S. Supreme Court, under the direction of Chief Justice Earl Warren, accelerated the process of guaranteeing individual rights in the face of criminal prosecution. Warren Court rulings bound the police to strict procedural requirements in the areas of investigation, arrest, and interrogation. Later rulings scrutinized trial courts' procedures and enforced humanitarian standards in sentencing and punishment. In 1966, the famous Miranda v. Arizona case decided that the police must read you your rights if you become a suspect under arrest. Since then, all arrests must follow the Miranda rights advisement. Police departments across the country are now implementing body cams to review footage if there is any accusation of police abuse of power, such as police intimidation, interrogation, or any other abuse. Abuse of power has always been a problem, but with the sophistication of new technologies such as body cams and vehicle cameras, it can help reduce abuse.
Individual rights. The Constitution of the United States provides for a system of check and balances among the legislative, judicial, and executive branches of government. The system is designed to ensure that no one individual or agency can become more powerful enough to usurp the rights and freedoms guaranteed under the Constitution. People that feel they have not received the respect and dignity from the justice system that are due under the law can appeal to the courts for redress. Such appeals are usually based on procedural issues and are independent of more narrow considerations of guilt or innocence in a particular case.
Search and seizure. The Fourth Amendment was adopted by Congress and became effective on December 15, 1791. The Fourth Amendment to the Constitution declares that people must be secure in their homes and in their persons against unreasonable searches and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Exclusionary rule. Evidence illegally seized by the police that cannot be used in a trial. Weeks v. U.S. is the first landmark case concerning search and seizures. The Weeks case forms the basis of what is now called the exclusionary rule. Fremont Weeks had violated federal law and was convicted by a jury, but he escaped punishment because of the illegal behavior of the police. Fruit of the poisonous tree doctrine is any evidence that derives from a seizure that was in itself illegal cannot be used at trial. Good faith exceptions to the exclusionary rule. Officers who conduct searches or seize evidence on the basis of good faith who later discover that a mistake was made and may still provide evidence that can be used in court. Probable cause, based on facts and circumstances that would cause a reasonable person to believe that a particular other person has committed a specific crime. Plain view doctrine. Objects falling in the plain view of an officer who has a right to be in the position to have that view are subject to seizure and may be introduced in evidence. Applies only to sightings by the police under legal circumstances, that is, in places where the police have a legitimate right to be, and typically only if the sighting was coincidental. Emergency searches of property and emergency entry. Searches conducted without a warrant when special needs arise are legally termed exigent circumstances searches. Officers must demonstrate that a dire situation existed that justified their actions. If unsuccessful in court, will taint any evidence seized and make it unusable. Anticipatory warrants. Search warrants issued on the basis of probable cause to believe that evidence of a crime, although not presently at the place described, will likely be there when the warrant is executed. It requires an issuing magistrate to determine that it is probable cause, contraband evidence of a crime, or a fugitive will be on the described premises when the warrant is executed.
Arrest. An arrest is defined as the act of taking an adult or juvenile into custody, meaning that he or she does not have the freedom to leave. An arrest can also lead to questioning the suspect, meaning that the police officers would then ask for their information. Most of these arrests that are done by officers must have a probable cause in order for that full arrest. The officers then come to a conclusion that the person in custody has or has not committed the crime. Therefore, most of these arrests tend to lead to searches, meaning that once this arrest has been made, an officer may search the person for his or her belongings and her immediate surroundings. Another example of searches is mainly based on the officer's safety to see whether or not that individual that has been arrested may or may not have any weapons on him based on that arrest done by officers. Most of these arrests that are done by law enforcement are done regardless of the gender, whether it's a male or female. Another great example on arrest is the Terry type stop. This Terry stop is known as a reasonable of suspicion done by a law enforcement. Mainly throughout this arrest that is done is mainly that the officer might be suspicious of individual about a committed crime in progress or criminal activity. Mainly throughout this arrest or throughout the stop, the officer does not need a probable cause in order to go ahead and confront the individual. An example of this Terry stop is mainly that the officer would go ahead and approach the individual, ask them to stop, and then he would go ahead and frisk and pat down the individual to see whether or not he has any weapons on him. Throughout this arrest, the officer would then go ahead and ask for the individual's information to see whether or not he or she will comply to the officer's rules. Last and foremost, another example of an arrest is the Stop and Identify law. This law was created after a Hibble versus 6th Judicial District Court of Nevada back in 2004. This law simply authorizes police to legally obtain the identification of someone whom they reasonably suspect of having committed a crime. Based on these stops, an individual must provide information to the police officer to be able to identify themselves after the stop. The way that this stop works is simply related to a Terry stop, in where the officer goes ahead, pats down the individual for a search of whether or not he or she may have any weapons, and basically for the safety of the police officer. The Stop and Identify laws do not apply to every state. There are several states that do not allow this law in happening.
Okay, so I will be doing the intelligence function. This is how officers are able to gather information and make an arrest. So when a crime occurs, law enforcement, they try to use witnesses and informants in order to get a lead on who committed the crime. The problem with using informants is that one, they use paid informants, which sometimes they get away with minor crimes, and then two, they sometimes are able to make kind of like a deal for people that committed crimes if they testify against a certain individual, or sometimes they just let them go free. So there have been studies made where they concluded that witnesses and informants they play a big role in helping law enforcement to capture these criminals. It might take the law enforcement officers a little longer if they don't have informants and witnesses, so they won't have as many leads. So it's very helpful for them to have these people. And then there was a case which was Aguilar versus Texas. Um, in order for them to get a probable warrant, they have to have a probable cause. So the court determined that an informant's information can be used as probable cause. The thing is, the information must be clear, and police officers have to have a reasonable belief that the information given is reliable in order for them to get that warrant. They can't just get a warrant based off of any person's information because most of the times it's not reliable. When police officers are trying to get a confession, there are some rules they have to follow. So here we have some cases. For physical abuse, Brown versus Mississippi, they determined that police officers cannot physically abuse somebody just to get a confession. The inherent coercion was the Ashcraft versus Tennessee. So this one, they said that they cannot force somebody to confess. They can't have too much pressure on them. And then for the psychological manipulation was the Arizona versus Fulminant. For this one, the investigators have to be honest with the suspect. They cannot lie to them. They can't trick them into confessing. And then the right to a lawyer. We have two cases, which is the Escobedo versus Illinois, and then the Minnick versus Mississippi. And then we have the famous Miranda rights. So the Miranda rights, basically there are five statements that the police officers have to make before a confession or before an arrest.